touch on the scope and application of the protection of the right to life, as it is proclaimed in Article 40, paragraph 3, sentence 1, 2 and 3 of the Irish Constitution, the protection of the family, Article 41, and the protection of rights to education, Articles 42, 44, paragraph 2, 4 and 5 of the Irish Constitution. You need not know in detail what is written here. It is decisive, however, that the Irish Constitution, which is supposed not to be touched on by the regulations of the Lisbon Treaty, a treaty which gives the Charter of Fundamental Rights a legal status. To be precise, Article 6, paragraph 2 of the EU Treaty, here is written that the Treaty of Lisbon has the same liability as the treaty in general. There is no substance to it, nothing at all, so it cannot violate any material rights, to be precise. If you want to be friendly and say that they believe that the Charter of Fundamental Rights does not impair these rights, the fundamental rights in their full content, let us assume that, although it's not written in the text. Well, you really have to concentrate to be able to understand, don't you? Moreover, the regulations of this treaty in the field of freedom, of security and law, that is, the police law, criminal law and civil law, what is regulated here. And now comes the most essential aspect, the range of application, the applicability of these fundamental rights on the Irish Constitution, protection of life, protection of family, and the right to education. Of course, it is absolutely clear that the Charter does not at all touch on the domain and the scope of application of the national basic laws. What is said here is nothing, for it is absolutely clear that the Charter of Fundamental Rights, this is put down in Article 51, can only be applied to European legal acts. This means judicial regulations and other acts. The Charter cannot be applied to national legal acts, German, Austrian or Irish ones. Not at all. And the Irish principles are only valid for these national acts. It is not provided here, in this document, that the Irish basic constitutional rights are also valid for European enactments. That would be wonderful, of course, wonderful, yes, but there isn't a single word about that. Of course, these are very difficult terms, which only somebody who has been dealing with them for years, in a painful way, as in the interest of law, can be familiar with. So what does that mean? Range of application, field of application. These are very precise terms. Range of application means the treaty is valid under the rule of international law in Austria, in Germany, but because of its dualism, to make it short, it is at the same time not applicable. The Union's law claims a higher priority of application, but the whole body of national law remains applicable too. If the terrain is pertinent, that means if there are national provisions touched on. We are having this juxtaposition, but they have to be carefully separated. According to the Charter of Fundamental Rights, collision of European and national fundamental rights does not exist. By the way, I hope nobody will be confused now. 80% of our legal acts are European anyway, and in these acts the European Charter of Fundamental Rights is valid in Ireland as well, and this will remain like that too. This document does not change anything about that, does not protect the Irish no more than they were already protected before. That is the state of affairs. They do not gain anything by this text, nothing, and that is quite logical if we look at the term. I only want to mention, shortly, that the contents of the Irish legislation concerning the family is a remarkable one, an excellent one. However, the Irish family legislation has long since been trampled on because of its membership in the European Union. Because nothing of this legislation is left. And if the Irish rejected the Lisbon Treaty now, they would actually reject the validity of all treaties, since the Lisbon Treaty is only a repetition. If you permit, Mrs. Rauscher, I would like to read that for Ireland. The state acknowledges the family as a natural and fundamental unit of society and as a moral institution with unalienable and unexpiable rights before and above all positive law. It is religion, yes, installed by God. Marriage has a religious state. The state guarantees the protection of the family, its structure, its acknowledgement as a necessary foundation of the social order, as indispensable for the common weal of the people and of the state. The state acknowledges in particular, now, women, don't you listen, that the women will support the state by their lives in the homely community, because the common weal cannot be attained without that. The state will take effort to secure that women will not be forced by reasons of economic necessity and to the damage of her household work to take up employment. I'm only reading. The state commits itself to preserve the institution of marriage, on which the family is built up with particular care, and to protect it from attacks. It is added that, if you are divorced, that is, divorced abroad, you may marry in Ireland only if the divorced partner has died before. I am only saying that. That is the Irish constitution, and I am of the opinion that the Irish decide on their constitution and only them. It is not us who have to decide. We shape our own constitution, and of course we may have quite a different view. But one thing is altogether obvious, that the whole European legislation, which I cannot present to you now in detail, the whole body of the social legislation has only one goal: to force women into employment. Yes, by means of a sprawling ideology. Why? Permit me to answer that question in short. Because then you have two people working, one who would normally work, the man, and one who will work as busy as a bee, that is the woman, since you need two for the same wages. For the income of man and woman together does only just suffice to feed the family. Contrary to human rights, since in all declaration of human rights we find the provision that the remuneration has to be such that the employee and the men were meant thereby, and that is still valid today, that he can adequately feed and sustain a family. To sustain himself and his family, these are texts from the 50s and even the 60s. A family was a family of 7 or 8 at that time. For most people, the wages are simply illegal today. In Thuringia, Germany, 61% of the employed receive Hartz IV payments additionally. That means social welfare payments. Let me shortly say something about taxes. The tax regulation is reserved to the Irish. That means it is their range of authority, but it's absolutely meaningless. The Union can equip itself with equity capital and invent new forms of equity capital, and also here Ireland must vote yes, because that must be decided unanimously. That is what it means. Ireland preserves its taxing authority. That is nothing. I do not want to speak about the issue of neutrality now, which was written into the treaty for Austria as well. It is a little precarious to go into detail here, but by and large we can say that also after the Treaty of Lisbon, neutrality in the military field will be kept up, as far at least as this is still practicable. I cannot go in detail because of the time, but be sure, the Irish are not conceded anything, nothing at all. It's a mere shame. And with respect to the issue of commissioner, that Ireland too must have a commissioner as well as any other member state. There is nothing written about this issue in the text. That is an auxiliary decision. Its legal status is more than dubious. It is said that the heads of states and governments can determine a new number of commissioners' names. That is dubious, however, and one could deal with the problem in this context. But I don't want to keep you any longer. Thank you for your attention, and I have tried to make it short. Yes, indeed, quite contrary to my practice.